Hi, everyone, and welcome to Talk Rights to Me. I'm Elizabeth Lyons, a master's student and researcher at the Human Rights Research Center. My research generally looks at migration and women's rights, and I'm especially interested in how human rights violations and conflicts can lead to displacement. Today with me is Irem Cakmak, a legal research assistant, also at the Human Rights Research Center, and who has immigration law firm experience from around the world. Today, we're specifically going to be talking about the US asylum system, what it is, how it works, and some of the recent changes that affect people seeking protection. So, yeah, I'm really glad we're talking about this.
Yes, thank you very much for Elizabeth having me today. I think our conversation today will be an important one. Unfortunately, I do not think I will be able to paint a very positive picture today, but I think these conversations need to happen for us to improve and protect human rights even more broadly. So thank you very
Certainly.
much for the opportunity.
Yeah, no, thank you. All right, so to start off, let's just go over the basics. What is asylum and how does the system generally work in the US?
Asylum is essentially a form of protection. It is granted to people who cannot safely return to their country because either they have suffered persecution or they have a well-founded fear of persecution. In the United States, a person may apply for asylum either if they're in the country or they're at a port of entry. But the main question here is why they cannot return to their country. The manner the person entered the US is not the core definition of asylum eligibility. However, it can affect which procedure they go through. And in the US, asylum works on two main procedural tracks, namely affirmative and defensive. Affirmative asylum means that a person applies for asylum proactively. So this process is generally for people who are not already in removal proceedings. So usually for people who enter the US with a visa or another temporary status. I want to note that it is not limited to people who still have this status. So a person may apply for asylum if they are overstaying their status, but they weren't placed in removal proceedings. These applications are handled by the USAS, and if asylum is granted, the person becomes an asylee, so they would be authorized to work, and they might apply for lawful permanent residence after 1 year as an asylee. If the USAS does not grant the case, they refer the case usually to immigration court, where it continues as a defensive case, which brings us to the second track, defensive asylum. It means that a person applies for asylum as a defense against being removed from the United States. There are several ways for a person to end up in removal proceedings. It could be after a border encounter, it could be after interior apprehension, it could be after overstaying or violating status, or as we mentioned, it could be a referral from the USAS. Here, the claim is being raised inside the immigration proceedings, but unlike criminal proceedings, there is no general government appointed lawyer here. So, although the person has the right to be represented by counsel, if they want to do so, they need to find a lawyer themselves and handle the expenses, basically.
Mhm.
And if relief is denied here, the person may face removal order and they may generally appeal the decision. The existence of a two-track asylum system is not by itself inconsistent with international law. One of the most relevant principles here is principle of non-refoulement. In simple terms, this principle means that a state must not return a person to a place where their life or freedom would be threatened. And this principle is recognized as a customary international law, so it is legally binding on all of the states. And it is also absolute, meaning that there are no exceptions to this rule. And again, regarding asylum protection, this principle may require a state to provide access to a procedure through which a person can present a claim. They have that claim examined individually and effectively before removal to prevent wrongful return. And again, the US two-track system does not create a tension with this rule. However, a stronger international concern arises from more recent developments, I would say.
Just to kind of restate that in simpler terms, asylum is a form of protection for people who can't safely return to their home country. There's two ways to do this in the US, and there's a legal process for that. I think that's a really helpful starting point because from there, the process can look different, as you've already started to explain. So, building off that, it seems like in recent years, it's become more difficult for people to apply for asylum at the border at the US. What do you think are the reasons for that?
You're definitely right. I do believe it has become much more difficult to apply for asylum at the border. It is mainly because the landscape has become almost impossible to follow. So much has happened and changed. Even the rules that were introduced in later years are either reversed or changed, and we can see a shift in different stages of asylum process or seeking protection. So first, as we mentioned, for a person to apply for asylum in the US, they must either be in the country or at a port of entry. However, we see that it has become much more difficult to enter the country from the border. Secondly, even after physically entering the country, before applying for asylum, those who seek protection might need to navigate through an expedited removal process. They might have to deal with mass and arbitrary arrests or backlog of cases in the court. So in this question, I first want to talk about the situation at the borders. We see that many more pathway restrictions are imposed in recent years that make the legal landscape extremely complex. For example, in 2023, after COVID-related border closures expired, circumvention of lawful pathways rule took effect. What it did was creating an assumption that if a person did not use certain pathways that were considered lawful, that they should not receive asylum. These lawful pathways included obtaining travel authorization through a DHS-approved parole process. It included appearing at a port of entry with a pre-scheduled time, uh, and seeking asylum or another form of protection in a transit country and receiving a final denial there. So the most widely accessible legal pathway was here scheduling an appointment at a port of entry. And it was most commonly done by an app called CBP1. This means that if a person used CBP1 app to schedule an appointment at a port of entry, they would be deemed to have entered the country through a lawful path. So they would not have this negative assumption attached to them. It is possible to turn this assumption around. However, it made the process much more difficult from the beginning. And this rule applied to anyone who entered the United States between May 2023 to May 2025. But what happened in 2025 was that Trump administration issued a proclamation that framed movements at the border as an invasion. So they ended CBP1 app scheduling function, and at the same time, they canceled all of the existing appointments. So many people who have been waiting for months at the border to be able to enter the US through a lawful way have lost their way to do so. And it became unclear which pathways were considered lawful. And to my knowledge, no comparably accessible replacement for the appointment mechanism was made available at the time. So it is important because it was one of the most commonly used pathways. So again, it has become much more harder to seek asylum at the US border because the landscape got more and more complex very fast. Another reason for this hardship could be the government also took active and more direct measures to limit movements at the borders. In 2024, Biden administration introduced a set of measures called Securing the Border, and these measures allowed the government to suspend and limit entry during periods of high border crossings. So the government would rely more on quick return mechanisms instead of normal asylum process. In practice, this would mean that border capacity itself becomes part of the legal asylum system because it makes possibility to apply for asylum dependent upon the manner and time of entry, and it undermines due process and also asylum protections guaranteed by the law. Another reason I want to mention here is that militarization of the borders. Again, in January 2025, Trump administration declared a national emergency at the southern border, and this expanded military involvement so that borders become more controlled and much more securitized. So people who need asylum protection and are unable to use regular routes to enter the country might encounter troops, might encounter surveillance systems, and faster interception before they even reach a meaningful protection process. These policies contradict US's international law obligations, and at the international level, one of the most central legal instruments is the 1951 Refugee Convention and its 1967 Protocol. And the US acceded to the 67 Protocol, and by doing so, they undertook to apply the core operative protections of the convention itself as well. The convention includes protections against discrimination in Article 3. In this case, lawful access routes are restricted, cancelled, and made partially unavailable, and asylum seekers are then disadvantaged for entering irregularly. Also, these measures raise concern regarding principle of non-refoulement, especially when they block access to asylum procedures or result in return without an adequate individualized assessment of risk. So in conclusion for this question, the measures also disregard the asylum seeker's situation. The fact that the asylum seekers often cannot use ordinary immigration routes to reach safety is completely overlooked. And as a result, their access to an asylum proceedings are basically ripped away.
Got it. That really helps to provide context. It sounds like there isn't just one reason, but a combination of a variety of factors. If I'm understanding correctly, for someone at the border, these changes are detrimental, especially with the CBP-1 app. It's hard to understand when you can legally enter the country if there's not a system in place to do that. So the CPB1 app is not, we don't use it anymore at all.
So it is not used currently because its again scheduling function ended in 2025, but I believe it still legally matters because the rule applied to anyone who entered the US from a border between May 2023 to May 2025. So even if the app is not used today, many asylum seekers who entered between that 2-year period are obliged to or are expected to explain before an immigration judge why they didn't use the app or why they were unable to use the app. And from my experience, many clients did not even know what this app was. Most of them did not speak the provided languages in the app. And considering that the government automatically does not appoint an attorney for immigration proceedings, and considering that using CBP-1 is still an eligibility criteria for many asylum cases, again, access to a meaningful asylum proceeding becomes unduly difficult.
Another part of this conversation, I think, is immigration detention, especially because of the environment in the US right now. We've been hearing that detention is increased. Why is that? How does it affect people going through the process? Stuff like that.
Yeah, so there is a significant increase in immigration detention because the US government started to increasingly treat migration and asylum as a security issue rather than a legal protection issue. And a major reason for the increase is the shift in policies. Immigration detention is supposed to be a civil custody tool, not the default response to every asylum seeker or every undocumented migrant. And previously, it was used much more selectively. People without criminal records made a smaller portion of the detained population compared to today. and detention was more strongly associated with alleged public safety concerns. But we see that this is no longer the reality. One of the biggest challenges is that even immigrants and asylum seekers without any criminal record are under the risk of being detained. For instance, according to Brennan Center of Justice, around 73% of the people in immigration detention do not have any criminal record as of February 2026. So what we do not see here is that the detained population suddenly becoming more dangerous. So it is only the changing policy, changing funding opportunities, and the legal atmosphere. I want to add that detention is no longer limited to borders. So people are being arrested at workplaces, right outside of immigration court buildings, and even during routine ICE checkings. So what we see from these developments is that detention is no longer a consequence of non-compliance with the law. People can now be detained even when they are doing exactly what the government told them to do. For instance, if someone is placed in removal proceedings, they have to attend the hearings, because if they do not, then the immigration judge might deem their claim abandoned. And if their claim is deemed abandoned, they might be removed from the United States. So they have to attend the hearings. But if they attend the hearings, then they might be arrested by ICE. So people are placed in this impossible dilemma where there is no correct answer as to what to do and how to be safe. I want to note that with perspective changes like these, of course, come the funding opportunities. So ICE today is the largest federal law enforcement agency by budget, and they are investing in making deals with new detention centers, even warehouses to use them as detention centers, or they are increasing bed capacity. So this growing reliance on private contractors also raises accountability concerns, especially if the detention conditions or treatment give rise to human rights violations. With that said, there are already many challenges faced in immigration detention. One of them would be difficulty in preparing the asylum case, because being detained seriously limits access to counsel. It seriously limits access to evidence or witnesses. Other challenges might include inadequate healthcare, inedible food, or even psychological pressure. So in my experience, some of the people I have worked with reported that they were suddenly moved between detention facilities without letting their families know. They were awakened at odd hours. They were threatened with imminent deportation, or they were even pressured to sign documents that they do not understand. So this new perspective, of course, creates tensions with international law. Immigration detention is not prohibited per se, but it must not be automatic, it must not be punitive in effect, or it must not be imposed without an individualized assessment of necessity and proportionality. And in addition, detention conditions may, depending on the severity or cumulative impact, may amount to cruel, inhuman, or degrading treatment even. So taken together, these developments create an environment that is less and less compatible with the US international law obligations.
Yeah, that makes sense. Detention can shape someone's experience pretty significantly while their case is being processed, and that's, not even talking about the fear and other things that happen, like leading up to that process. One of my favorite sayings is like caught between a rock and a hard place. And this is that in a very simplistic way of speaking. So beyond what happens at the border and everything that we've talked about, there's also the affirmative asylum process for people who are already in the US. We've talked about that a little bit, but I was wondering if you could explain like a little bit more about what that process is, and if there have been recent changes given how many disruptions and changes there has been in the American asylum system.
There have been some significant changes in the affirmative asylum procedures as well. In practical terms, affirmative asylum also became slower, more expensive, and even less predictable. So, as we mentioned, affirmative asylum cases are being handled by the USAS. And since 2018, they have a last in, first out policy. The main idea here was to deter weak or fraudulent filings to reduce the backlog. Um, However, we see that the backlog is still there. And of course, this has some consequences for asylum seekers. So for people who filed recently, they can be called for an interview very quickly, which may leave them with less time to find counsel, less time to gather evidence. They might not be able to obtain translations, or they might not even be able to prepare psychologically for the interview itself. On the other hand, other people who have filed their applications uh, before, they might have to wait years for an interview, and this might make their case appear weaker because witnesses might become harder to reach, conditions in their home country might change, they might have hard time accessing evidence, and of course, memory naturally fades sometimes, and any detail forgotten, any contradictory detail said during the interview will be interpreted negatively. In addition to last in, first out policy, we also see a decision pause in November 2025. The USAS declared that they will conduct the interviews for asylum applications, but they will not issue decisions. So an applicant will not be able to work on their case after an interview, but they will also not receive an asylum protection. So they are left in this legal limbo, basically. The USAS announced that they partially lifted this decision hold, but this happened on March 30th, 2026. So we are still waiting to see how this will take effect. Aside from the backlog of cases in the USAS, there are a couple of broader changes that affect both defensive and affirmative, I must say. I wanted to point this out because this is also very significant, I think. There are now fees associated with asylum applications, although there are two types of filing. So there's an initial filing fee and there's an annual pending asylum fee. Although these are around $100, they still put a financial burden. So they make financial capabilities a part of asylum eligibility, I think, which is quite interesting and quite concerning. In addition to that, one has to make a living while they're waiting for their asylum decision. But to do that, they need work authorization. But acquiring work authorization also become much more expensive, around 500 US dollars for initial application. Also, their validity period was shortened drastically from 5 years to 18 months even. So people need to keep applying maybe every 18 months, so they need to spend $500 every 18 months, which might not be feasible for many asylum seekers, many people who are fleeing persecution. So I want to say that frequent rule changes make the system very hard to navigate, even for represented applicants, but much more harder for underrepresented ones. And new fees, shorter validity of work authorization, decision pauses, these all increase instability. So even though the right to apply still exists, the pathway has become much more complex, much more expensive, and much more unstable.
Yeah, yeah. There are so many moving parts here, different processes, different entry points, different and inconsistent changes over time affects people's lives and how everything works. Um, so even just understanding the structure, as you've talked about here, can make a really big difference. Thanks for talking through all of this.
Thank you. I hope it is helpful somehow, and I hope it wasn't too hopeless. I do think efforts from civil society have a chance to make a difference, and especially community helping each other out, helping asylum seekers as well. So I hope this becomes a step for that.
Yeah, me too. Um, yeah, so I'm Elizabeth Lyons. This is Irem Cakmak. And thanks for listening to Talk Rights to Me.